The nature of the crime is of considerable importance. It may be of such significance or so far-reaching that a lengthy period of imprisonment is the only adequate punishment. In passing sentence, the trial court must take into account the moral and ethical nature of the crime and the gravity of the offense. It is accepted and is indeed logical that a more serious crime will carry with it a greater moral blameworthiness than a minor or less serious offense. This involves a moral and value judgment. A process of arid intellectualism is insufficient. Mere theorizing is insufficient. What matters finally is how the court views the crime on its own merits, and all the relevant proven facts and circumstances must be carefully considered and assessed. Merely to find that a crime by itself is serious without regard to its setting and its factual context, and thereby concluding that the crime committed by the offender is therefore also serious, is not appropriate and may result in a serious misdirection. The court does not and cannot rely on a catalogue of crimes. To do so would result in a purely mechanistic approach whereby the court, in its judicial discretion, would fail to pay due regard to the facts and circumstances of the particular crime. The sentence, therefore, must be commensurate with the gravity or otherwise of the crime and is a necessary concomitant of punishment. See State v. Haasbroek, 1969, Volume 1, SA 356E. In considering the offender, due regard must be had inter alia to the following: his or her age and background, level of education, attainment and position in society, family circumstances, whether married or not, and the question of dependence, motive in committing the offense, whether for personal gain or for reasons of avarice, or being actuated by some moral or laudable objective, whether the offender stood to gain by the offense, the question of the accused being a first offender, the effect of punishment on the offender, and more particularly, if a sentence of imprisonment is imposed, the prospects of reformation and correction, and becoming a useful member of society. The presence or absence of remorse or contrition, whether, instead of imprisonment, an alternative method of punishment would not be appropriate in the circumstances. A perceptive understanding of the accused's human frailties as affected by the circumstances surrounding the commission of the offense in question, and a balancing of those frailties against the evil of the offender's deed. The authority for that is State v. Sebolai, 1967, Volume 4, SA 566, Appellate Division Decision Case at page 571, paragraphs E to F. Also, look at S v. Lenberg, Ena Under, 1975, Volume 4, SA 533, an Appellate Division Decision Case. Due weight must be given to the personal circumstances of the accused. As a general principle, equal punishment for equal offenses is to be imposed unless the personal characteristics of the respective accused make such differentiation necessary. The feelings and requirements of the community, the protection of society against the accused and other potential offenders must be considered, as well as the maintenance of peace and tranquility in the land needs to be taken into account. Whilst considering the interests of society as a factor in determining sentence, the interests of society should not be overstressed to the detriment of the personal factors of the accused. I pause to mention that a balance should be maintained between the different elements of the triad. It is noteworthy to mention that this triad has been criticized as inadequate, as the role of the victim is not emphasized. This anomaly has caused the courts to now give serious consideration to the victim during sentencing proceedings. This phenomenon has been termed as the squaring of the triad. An enlightened and just penal policy requires consideration of a broad range of sentencing options from which an appropriate option can be selected that best fits the unique circumstances of the case before court. And that principle was set out in Samuels versus the State, 2010, Zaska, page 113. To that should be added, it also needs to be victim-centered. Internationally, the concerns of victims have been recognized and sought to be addressed through a number of declarations, the most important of which is the UN Declaration of the Basic Principles of Justice for Crime and Abuse of Power, which is contained in Resolution 40/34 and adopted by the General Assembly on the 29th of November 1985. The declaration is based on the philosophy that adequate recognition should be given to victims and that they should be treated with respect in the criminal justice system. In South Africa, victim empowerment is based on restorative justice. Restorative justice seeks to emphasize that the crime is more than the breaking of the law or offending against the state. It is an injury or wrong done to another person. And that has been dealt with by the SA Law Commission Discussion Paper 7, where it dealt with sentencing restorative justice in 1997. The underlying philosophy of the Service Charter for Victims of Crime in South Africa, which is contained in Section 7, subsection 1 of the Constitution of the Republic of South Africa 108 of 1996, also referred to as the Victims' Charter, is to give meaningful content to the rights of all citizens by reaffirming one of our founding democratic values, namely human dignity. The Charter seeks to give to victims the right to participate in and proffer information during the sentencing phase. The victim is thus afforded a more prominent role in the sentencing process by providing the court with a description of the physical and psychological harm suffered, as also the social and economic effect that the crime had and in future is likely to have. By giving the victim a voice, the court will have an opportunity to truly recognize the wrong done to the individual victim. By accommodating the victim during the sentencing process, the court will be better informed before sentencing about the after effects of the crime. The court will thus have at its disposal information pertaining to both the accused and victim, and in that way, hopefully, a more balanced approach to sentencing can be achieved. Absent evidence from the victim, the court will only have half of the information necessary to properly exercise its sentencing discretion. It is thus important that information pertaining not just to the objective gravity of the offense, but also the impact of the crime on the victim be placed before the court. That in turn will contribute to the achievement of the right sense of balance, and in the ultimate analysis will enhance proportionality rather than harshness. That principle has been carried in the case of State versus Machichi, 2011, Volume 1 SACR, page 40. It's a Supreme Court of Appeal Supreme Court of Appeal decision, paragraph 17. Mercy is regarded as a concomitant of justice. In State versus Rabi, 1975, Volume 4, SA, Appellate Division Decision Case, at page 861, D et sec, Holmes J.A. stated, and I quote, "Then there is the approach of mercy or compassion or plain humanity. It has nothing in common with maudlin sympathy for the accused. While recognizing that fair punishment may sometimes have to be robust, mercy is a balanced and humane quality of thought which tempers one's approach when considering the basic factors of letting the punishment fit the criminal as well as the crime and being fair to society." Close quote. The principal conviction in this case relates to the callous, merciless, and heinous killing of the deceased by the accused. Mr. Kumalo? The second conviction relates to the fact that the accused, after stabbing the deceased, then deemed it fit in the circumstances to clean the flat by mopping up the blood, change the clothing of the deceased, remove the murder weapon and clothing of the deceased from the scene. The accused has been found has been found guilty inter alia of murder read with the provisions of section 51 subsection 2A of Act 105 of 1997. Part 2 of Schedule 2, which in the case of a first offender prescribes the imposition of a minimum of 15 years imprisonment for murder. In the seminal judgment of State versus Malchas, 2001, Volume 1, SACR 469, Supreme Court of Appeal, at paragraphs 7 and 8, the following was said per Murray J.A. regarding the provisions of the minimum sentence legislation. And I quote, "The very fact that this amending legislation has been enacted indicates that Parliament was not content with that, and that it was no longer to be business as usual when sentencing for the commission of the specified crimes." Close quote. Open quote. In what respects was it no longer to be business as usual? First, a court was not to be given a clean slate on which to inscribe whatever sentence it thought fit. Instead, it was required to approach that question conscious of the fact that the legislature has ordained life imprisonment or the particular prescribed period of imprisonment as the sentence which should ordinarily be imposed for the commission of the listed crimes in the specified circumstances. In short, the legislature aimed at ensuring a severe, standardized, and consistent response from the courts to the commission of such crimes unless there were and could be seen to be truly convincing reasons for a different response. When considering sentence, the emphasis was to be shifted to the objective gravity of the type of crime and the public's need for effective sanctions against it. But that did not mean that all other considerations were to be ignored. The residual discretion to decline to pass the sentence which the commission of such an offense would ordinarily attract plainly was given to the courts in recognition of the easily foreseeable injustices which could result from obliging them to pass the specified sentences, come what may. Secondly, a court was required to spell out and enter on the record the circumstances which it considered justified a refusal to impose the specified sentence. Moreover, those circumstances had to be substantial and compelling. Whatever nuances of meaning may lurk in those words, their central thrust seems obvious. The specified sentences were not to be departed from lightly and for flimsy reasons which could not withstand scrutiny. Speculative hypotheses favorable to the offender, maudlin sympathy, aversion to imprisoning first offenders, personal doubts as to the efficacy of the policy implicit in the amending legislation, and like considerations were equally obviously not intended to qualify as substantial and compelling circumstances. Nor were marginal differences in the personal circumstances or degrees of participation of co-offenders which, but for the provisions, might have justified differentiating between them. But for the rest, I can see no warrant for deducing that the legislature intended a court to exclude from consideration, ante omnia as it were, any or all of the many factors traditionally and rightly taken into account by courts when sentencing offenders. The use of the epithets substantial and compelling cannot be interpreted as excluding even from consideration any of those factors. They are neither notionally nor linguistically appropriate to achieve that. What they are apt to convey is that the ultimate cumulative impact of those circumstances must be such as to justify a departure. It is axiomatic in the normal process of sentencing that while each of a number of mitigating factors, when viewed in isolation, may have little persuasive force, their combined impact may be considerable. Parliament cannot have been ignorant of that. There is no indication in the language it has employed that it intended the inquiry into the possible existence of substantial and compelling circumstances justifying a departure to proceed in a radically different way, namely by eliminating at the very threshold of the inquiry one or more factors traditionally and rightly taken into consideration when assessing sentence. None of those factors have been singled out either expressly or impliedly for exclusion from consideration. Close quote. In State versus Malchas, Supra, State versus Dodo, 2001, Volume 1, SACR 594, it's a Constitutional Court decision, and State versus Vilakazi, 2009, Volume 1, SACR 552, a Supreme Court of Appeal decision, regarding the imposition of an appropriate and proportional sentence in the context of the prescribed minimum sentence of life imprisonment and the determination for when the prescribed sentence may be departed from. The following extract from Vilakazi, paragraph 3, is apposite, and I quote, "The Constitutional Court reminded us in State versus Dodo that punishment must always be proportionate to the deserts of the particular offender, no less but also no more. For all human beings ought to be treated as ends in themselves, never merely as means to an end." Close quote. Form SAP 69 confirmed that accused has no previous convictions. When the matter came before this court on 25 November 2015, Mr. Matopo, on behalf of the accused, duly informed this court that he was unable to proceed with mitigation of sentence as he was unable to secure a social worker's report. Ms. Leroux informed the court that she had no objection to proceed with the leading of the state evidence in aggravation of sentence. After having carefully considered the matter and taking into consideration the unnecessary delay that a postponement may have caused in the finalization of this matter, the court ruled that the state proceed with the leading of evidence in aggravation of sentence. I will accordingly hereunder proceed to appraise the evidence on sentence in the chronological order that it was presented. The state called the evidence of the following two witnesses in aggravation of sentence. Professor Rachel Catherine Jukes, hereinafter referred to as Jukes, who testified inter alia as follows. That she is the Director, Gender and Health Research Unit, Medical Research Council, and an Honorary Professor, School of Public Health, University of the Witwatersrand, Johannesburg. Jukes confirmed that she has undertaken numerous projects and research on abuse in respect of women since 1995. She confirmed the contents of a 39-page curriculum vitae, which undoubtedly classified her as an expert in her field, and more especially to authoritatively make submissions to this court regarding intimate partner violence and killing in South Africa. Her curriculum vitae was admitted onto the record of proceedings as Exhibit Y. Jukes submitted that the killing of women by male intimate partners is the most extreme form of intimate partner violence, as well as the most extreme consequence of intimate partner violence. She raised a concern that figures that were obtained from Tshwane schools in 2014, whilst not from a household survey, did not suggest that partner violence is on the decline. She regarded this phenomenon as extremely concerning, having due regard to the fact that government has identified violence against women as a national scourge, and over the last 2 decades has been working for its eradication. For example, through the Domestic Violence Act 116 of 1998, the government's 365 days of activism policy, and the 2011 launch of the National Council on Gender-Based Violence. A survey conducted in 2009 revealed that 57% of women who were killed, where the perpetrator was known, were killed by intimate partners. In addition, she submitted that South Africa's female homicide rate was 6 times higher than the global rate, and further that this was double than that found in the United States of America. A research conducted in 2013 by the Medical Research Council into the prevalence of intimate femicide globally revealed that from a data set of 66 countries globally, 39% of homicides of women were committed by an intimate partner. The study further found that women were 6 times more likely to die at the hands of a male intimate partner than men were to die at the hands of a female intimate partner. That the 2009 research revealed that intimate femicide is much more common in South Africa than in most other countries of the world, and the proportion of intimate homicides in South Africa is much higher than the global average, which is 57% versus the global average of 39%. Duke stated that in terms of the 2009 survey, intimate femicide is much more common among younger women and among colored and African women than older or white and Indian women. She submitted that very often there is a known history of previous intimate partner violence. She testified that it was very common for women victims of intimate femicide to have consumed alcohol. She confirmed that the blood alcohol level of the deceased, being 0.06 gram per 100 milliliters, was only slightly above the driving limit, showing that she was not heavily intoxicated when she was killed. Jukes profiled the age group for men who kill their intimate partners as being between 30 to 44 years of age. She referred to the research work conducted by Shanaz Matthews, hereinafter referred to as Matthews, and testified that during the interviews of her subjects, Matthews found that they described having experienced extreme harshness and cruelty in their childhoods at the hands of their parents, mostly their mothers or other caregivers. Mothers who were not cruel were often emotionally unavailable due to their own difficulties such as depression or alcoholism. Fathers were notably absent from their lives. All this resulted in the offenders growing up feeling unloved, insecure, and powerless. I pause to mention that the aforementioned criteria does not apply to the accused, as per his testimony and that of the social worker. Matthew's research also revealed that some of the men had characteristics which are commonly associated with borderline personality or narcissistic personality disorder, including low self-esteem, lack of guilt, lack of empathy, lying, or poor impulse control, with a tendency to react with extreme rage and aggression to perceived threats to self-esteem. Research chiefly conducted among black African men shows that South African men have strong expectations that they should be in control of their partner, respected by her, and that the use of violence within limits is a legitimate part of that control. It is noteworthy to mention that the accused admitted to slapping the deceased on occasion to keep her on track. Jukes stated that an area which is noted to particularly cause conflict is jealousy and practices related to having multiple partners. It is absolutely normative for South African men to have more than one sexual partner, especially younger men. She submitted further that it is particularly common for men to continue intermittently to have sex with the mothers of their children after they split up. Matthew's research had revealed that almost all her study participants had been repeatedly violent to their partner before she was killed. Often, the violence was from jealousy or to defend honor. For many, violence was entwined with substance abuse. I pause to mention that the evidence led during the trial is demonstrative of the accused being repeatedly violent to the deceased before she was killed. Most of the subjects interviewed described the act of killing their partner as one of snapping or losing control, but it was often an act which was committed to regain control. Most men felt belittled and humiliated at the point when they killed their partner and felt no remorse. At this point, they saw her as being of such little value that she deserved to be the victim of his outburst of extreme aggression. The killing was a final attempt to regain the upper hand over their partner, one who was no longer regarded as worth having. Jukes testified that in many jurisdictions, intimate partner femicide is viewed as a heinous crime and carries a heavy prison sentence. She testified that during 2012, the range for sentences in the Houston-Harris County, Texas, was between 20 to 50 years, with an average of 34.9 years. She drew a correlation with South Africa and pointed out that we characteristically have much shorter sentences for intimate femicide. In 2009, the Medical Research Council dataset showed that the average sentence for convicted perpetrators of intimate femicide was 12.5 years, with a range from 3 to 40 years. That 3 to 40 years. She submitted further that a simple ecological analysis would suggest that the much lower prevalence of intimate femicide in the US may be related to the long sentences that are given in such cases. In South Africa, it is easy to assume that our difficulty in reducing the problem of intimate partner violence, intimate partner femicide, may be part due to the short sentences that many perpetrators receive. Alternatively, the short sentences may reflect the generally socially permissive attitude towards partner femicide. Jukes unequivocally concluded from the documents that were presented to her, as well as the factual findings of this court in convicting the accused, that this case was a locus classicus of intimate partner violence, and that the court take this fact into consideration when imposing a suitable sentence upon the accused. That, in essence, concluded the evidence of Jukes. Mrs. Dikeledi Elizabeth Marawa, hereinafter referred to as Marawa, the biological mother of the deceased, who deposed to a victim impact statement on 24 August 2015, further testified inter alia as follows. I pause to mention that a victim impact statement is defined as, and I quote, a sworn statement by the victim or someone authorized by the victim to make a statement on behalf of the victim which reflects the physical, psychological, social, financial, or any other consequences of the offense for the victim, presently and in the future, close quote. Marawa testified that the death of the deceased has affected her emotionally and that she has spent sleepless nights for a period of almost 5 to 6 months. She suffered with loss of appetite and memory. Further, that the death of her child affected her mentally and emotionally, which resulted in her having nightmares. She was rather aggrieved at the manner in which the deceased was portrayed by the accused. She was rather upset about the defamatory statements that were made regarding the deceased, as well as the negative allegations in respect of her character. Marawa confirmed that she was attending counseling sessions on a monthly basis. The untimely death of the deceased has severely affected her health in that she experiences severe headaches, suffers from emotional stress, nervousness, and has suffered drastic weight loss. Her deteriorating health has caused her to consult various medical practitioners on many occasions. She stated that the deceased was the sole breadwinner who provided for her and the deceased mentally disabled brother. In addition, the deceased was also supporting her unemployed brother's children. The death of the deceased has severely affected her financially, as she has no other means of financial support. Marawa testified that the deceased was a God-fearing and kind person, a member of the Mothers' Union who also had a greater community at heart. She testified further that the deceased was studying towards a degree in psychology at the University of Witwatersrand and to have graduated in September 2014. Marawa submitted that as a result of the death of the deceased's daughter has been removed from her home by the estranged husband, who has prevented her from seeing the child. This state of affairs has caused her tremendous amounts of stress and heartache. It was put to this witness during a cross-examination that the accused apologized for the pain and embarrassment caused to her family, and further that he sympathized with her for the loss suffered. Marawa was adamant that if it were the intention of the accused to have apologized, he would and should have done so previously. That in essence concluded the evidence of this witness. It has just been brought to my attention that there seems to be a problem with the mechanical recording device, and the technician is attending to it. Would it require the court to adjourn, or would you be able to repair it? The court is going to take a short adjournment in order for the mechanical recording device to be repaired, and will continue as soon as it has been repaired. Mr. Sebolai, the court's going to take a short adjournment for the recording device to be repaired. Good. Court will adjourn.
I think it was, the principal research chiefly conducted among black
So long as everything is clear, the button
Yeah, we're coming back at 11:30. Yeah, you can tell everyone they can leave if they need. 11:30. Does everyone know we're coming back at 11:30?
We'll be back at 11:30. Stop at 11:30.
floor.